A historic day at the Supreme Court that could change the definition of U.S. citizenship. This morning, justices heard arguments on President Trump's attempt to limit birthright citizenship. It's a law that's been in place in our country for more than 150 years. Here's Jessica Hart.
The nation's highest court never hears easy cases.
Can a president revoke a right for people that is explicitly written in the Constitution of the United States with an executive order?
The right in question, a section of the 14th Amendment. President Donald Trump was at the Supreme Court to hear his Solicitor General, John Sauer, argue on his behalf on why he thinks it's within the president's power to limit automatic citizenship of babies born to undocumented parents.
8 billion people are one plane ride away from having a child who's a U.S. citizen.
Well, it's a new world. It's the same Constitution.
So the Chief Justice himself seemed quite skeptical, and other justices did as well.
Tim Johnson, a University of Minnesota political science and law professor, says the justices were skeptical because this constitutional amendment has more than 100 years of precedent. It goes back to the United States versus Wong Kim Ark, a man born in the U.S. but a son of Chinese immigrants.
Mr. Kim Ark made the argument that he had been born in the U.S. and therefore under the 14th Amendment, he needed to be and should be considered a citizen of the United States, and the U.S. Supreme Court agreed.
The 14th Amendment says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States.
The administration's argument is that the 14th Amendment is explicit only to former enslaved people in the United States, that because it was a series of amendments, the 13th, the 14th, and the 15th, which were meant to address issues of slavery.
Johnson says the American Civil Liberties Union that sued the administration over the order argues against that it wasn't just meant for former slaves.
Makes an argument that birthright citizenship, as written in the 14th Amendment, the plain words, doesn't say enslaved people. It says simply that anyone who was born in the United States is a citizen.
Johnson says both sides have legitimate arguments, but one is stronger.
When you look at the way justices make decisions, and in particular more conservative justices ideologically, oftentimes those justices decide on what scholars will call the plain meaning of the words. And in this case, the plain meaning of the 14th Amendment birthright citizenship clause is very simple to understand. Bottom line is anybody born in the United States on U.S. soil is a U.S. citizen.
The exchange you heard between the Chief Justice and the Solicitor General was about birth tourism. Johnson says the data suggests, as some lawyers have pointed out in other briefs, fewer than 1% of babies fall under the birthright citizenship clause. Jana.
And Jessica, to kind of get to the meat of what Tim was saying, it's just that, like, if you look at it on plain text, a textualist, what does it say? It does not say anything about the descendants of enslaved people. It just says people born here are American citizens, right?
Yeah, that's exactly right, Jana. Just to put it simply, it's everything you just said. People who are born here or naturalized on U.S. soil are U.S. citizens. There's no mention of people being formerly enslaved or slavery whatsoever.
All right, Jessica, and we expect a decision from the court in late June. Thanks for that report.